In this video, I will just give you some general information about the different lawsuits that are available to those that qualify. The first lawsuit would be Stark versus Blue Cross Blue Shield of North Carolina. This lawsuit has a payout, settlement has a payout of 1.6 million, and it's a cash fund that has been reached in a class action lawsuit claiming that Change Healthcare Resources LLC under the brand My Advocate, calling on behalf of Blue Cross Blue Shield of North Carolina, who are the defendants, sent pre-recorded voice messages to wireless telephone numbers without consent of the recipients in violation of the Telephone Consumer Protection Act, 47 U.S.C. Section 227. The defendants deny the allegation in the lawsuit, and the court has not decided who is right. If you're a settlement class member, your legal rights are affected whether you act or do not act. So, what are your options with this lawsuit? You can do nothing. If you do nothing but have been identified in defendant's records and have received a mail notice about the settlement, you will automatically receive a payment from the settlement fund and will give up your right to bring your own lawsuits against defendants about the claims in this case. If you do nothing but have been identified in defendant's records or have not received a mail notice about the statement, you will not receive a payment from the settlement funds or will give up your right to bring your own lawsuit against defendants about the claims in this case. You can make a claim. If you have not been identified in defendant's records or have not received a mail notice about the settlements, you may make a claim to receive a payment from the settlement fund. If you have been identified in defendant's records and have received a mail notice about the settlements, you will automatically receive a payment from the settlement funds without making a claim. If you wish to receive the payment electronically as opposed by check, you can check online at the website that I will give you. You can exclude yourself. You may request to be excluded from the settlement. If you do, you will not receive a payment from the settlement fund, but will not give up your right to bring your own lawsuit against defendants about the claims in this case. You can object right to the court if you do not like the settlement, and you can go to a hearing, ask to speak in court about the fairness of the settlement. Okay, what are the important dates? The exclusion deadlines will be December 2nd, 2024. The objection deadline will be December 2nd, 2024. The final approval hearing will be December 16th, 2024 at 9:30. And the claims deadlines is December 2nd, 2024. The website is www.myadvocatesettlements.com. The second settlement is satva.com false advertising class action settlement. This is 11.5 million settlement. And in this settlement, it resolves claims a retailer violated California and Oregon laws with deceptive discount advertising. The settlement benefits California residents who place one or more mattress order on satva.com between May 23rd, 2020 and May 23rd, 2024. The settlement also benefits Oregon residents who place one or more mattress order on satva.com between May 23rd, 2023 and May 23rd, 2024. According to the class action lawsuit, Satva misrepresented discount on his website, which deceived consumers into thinking they received good deals on products. This false advertising allegedly violated California and Oregon state law. Satva is an online mattress retailer. Satva hasn't admitted any wrongdoing but agreed to provide around 11.5 million in benefits to resolve the false advertising class action lawsuit. Under the terms of the Satva.com settlement, class members will receive a 115 benefit as a cash payment or a store credit voucher. The deadline for exclusion and objection is September 22nd, 2024. The final approval hearing for the settlement is scheduled for November 13th, 2024. To receive benefits from the Satva.com settlement, class action member must submit a valid claim form by October 27, 2024. So who is eligible? California class residents who place one or more mattress orders on Satva.com between May 23rd, 2020 and May 23rd, 2024. Oregon resident who placed one or more mattress orders on Satva.com between May 23rd, 2023 and May 23rd, 2024. There is no proof of purchase required. If you do not qualify for this settlement, do not file a claim. The website to make a claim is at Satva, SAATVA, mattresssettlement.com. Another settlement is the Magic Glove settlement, which is a company that's based in Illinois, is for $5.175 million. In this settlement, it resolves claims the company violated Illinois laws by using fingerprint time clocks and taking temperatures with scanners. The settlement benefits individuals who use the fingerprint scan time clock or had their temperatures taken using a scanner at Magic's Romeoville, Illinois facilities between January 8, 2016 and August 30th, 2024. According to the class action lawsuit, Magic Gloves used fingerprints, time clocks, and temperature scanners without giving the proper disclosure about collecting biometric information. Plaintiffs in the case argued that violated Illinois' Biometric Information Privacy Act. Per lawsuit guidelines, if you receive the notice of the settlement in the mail by text message or by email, then records indicates that you are employed by defendant at defendant's facility or a temporary worker assigned to defendant's facility during the relevant time period. If you use a fingertip scan time clock using a scanner at Magic's facility in Romeoville, Illinois between January 8th, 2016 and August 30th, 2024, you are entitled to a payment of up to approximately $3,244.38. If you had your temperature taken using a scanner at Magic's facility in Romeoville, Illinois between January 8th, 2016 and August 30th, 2024, you are entitled to a payment of up to approximately $135.26. If you use a fingertip scan time clock and you had your temperature taken using a scanner at Magic's facility in Romeoville, Illinois between January 8th, 2016 and August 30th, 2024, you are entitled to both payments. The proposed settlement is not an admission of wrongdoing by defendant, and defendant denies that it violates the Illinois Biometric Information Privacy Act or any other law. The court has not decided who is right or wrong. Rather, to save the time, expense, and distractions of litigation, the parties have agreed to settle the lawsuit. The deadlines have been listed, and you can go to www.magicglovebipsettlement.com for more information. Lastly, were you harmed in any way by Sean P. Diddy Combs? If so, you may have a claim. You can go to the websites www.legalfi.com or the website www.avalaw.com and fill out the claim forms as listed there. If you find this video interesting and would like to see more videos regarding lawsuits and settlements that you may qualify for, please give this video a thumbs up, like, and subscribe.